somebody to leak at the mid-level, right?
Well, you know, what I find ironic, of course, is the umbrage that some will take about some leaks. But I guess it's not their leaks. There are good leaks and bad leaks, I guess, is the bottom line. Mr. Nader?
Congressman, part of this goes back to the integrity of the civil servant and protecting it and letting civil servants and people who work in the armed forces in the executive branch take their conscience to work. And if you look at the civil service oath of office, it is not to the cabinet secretary. It is not to the president. It's to the highest moral standards. And a lot of this idiocy and overclassification comes from the lack of internal self-confidence that they will have some reasonable protection by civil servants who would say, this is foolish to do this. And I'll just leave you one example. 40 years ago, one agency of the government wanted to get from the U.S. Navy the amount of water pollution coming out of naval bases. And the Navy denied the then agency dealing with water pollution, they denied the disclosure of the volume of sewage going into the ocean on the grounds that the Chinese or the Soviets could use that information in order to determine how many sailors were on the base. Now that is a level of foolishness that could have been nipped in the bud if we supported our civil servants and basically recognized that this is overall a struggle between individual conscience of people up against the organizational machines that we call bureaucracy. And we always should bring back the civil service oath of office. Very short, very compelling. They all have to take it. We should protect them in making sure that it can be implemented in their daily work.
Thank you very much. Your additional time was granted at the leave of Steve King of Iowa. We now turn to the distinguished gentleman from Arizona, Trent Franks.
Well, thank you, Mr. Chairman. I appreciate it. I appreciate all of you folks being here. Challenging subject this morning. I think it's obvious to me, perhaps to all of us, that no human being, regardless of their education or training, is really competent to opine or to know the full extent of the actual damage that a leak like WikiLeaks could cause. I mean, I guess you could put a team of experts together to try to assess the future and the potential undetermined damage, and I just think that it would be completely a hopeless endeavor. So I'm convinced, obviously, that Julian Assange cannot possibly be able to project what the potential damage of what he did is all about. And that's a significant point. But in light of that obvious truth, I'm wondering if it's time perhaps for us to rewrite our statutes to establish some sort of lower burden for the prosecutor when it comes to proving the likelihood that a leak could cause actual damage and the necessary level of intent under the statute itself. Mr. Schoenfeld, you mentioned in your testimony that the ill effects of information leaks can sometimes take years to manifest. And you mentioned Pearl Harbor and the book The American Black Chamber as an example, which I think is a brilliant example, where the book disclosed certain things that perhaps could have prevented Pearl Harbor. And I'm going to try to get you to expand on that a little bit, and that our government, I understand, actually considered prosecuting the author of that book, but felt like the prosecution, the public nature of it might enlighten Japan even more than what the book did. So I'm hoping that you can describe what might have seemed to the outside observer to be the unforeseen consequences of the leaks through the book. And if hypothetically the author of the American Black Chamber were to be tried criminally for disclosing intelligence information today, what level of mens rea do you think a prosecutor would be able to show in this case? And I mean, I guess purposeful or malicious intent to aid in the bombing of Pearl Harbor would not be one of them. That probably would be a little too strong. But what about perhaps just recklessness? I know it's difficult to show malicious intent, but yet the devastation that was caused at Pearl Harbor, my last memory of that, reading the numbers on that war, is 50 million dead. It was kind of a big deal, the whole war. And So in light of this, do you think that we should reconsider the mens rea elements of our espionage statutes? And I've given you a complicated question there. Tell us about black chamber. Tell us how it all fits, and how do you think that we would approach that today?
Thank you very much, Congressman, for that very interesting question. Herbert O. Yardley was probably America's leading cryptographer in the 1920s. He was put out of his job after Secretary of State Stimson said, "Gentlemen don't read other gentlemen's mail." Fell in hard times in the Depression and wrote a book called The American Black Chamber. Basically wrote it to make a pile of money. He laid bare in that book the full history of American code-breaking efforts, including our successes in the Washington Naval Conference of 1921, where we broke the Japanese diplomatic codes and were able to outfox them in those negotiations. When that book came out, it was treated much like Eric Lichtblau regarded his own story in the Times as a kind of interesting yarn. Highly entertaining was what some American newspapers said about it. But in Japan, it caused an absolute furor about the laxity with which their own government had treated their codes and ciphers. And it led the Japanese government over the course of the 1930s to invest heavily in additional code security. And they developed the Purple Machine, which was nearly unbreakable. And one of the consequences was that it delayed it slowed down the pace at which our resurrected code-breaking effort could read Japanese cables. And we were somewhat behind when Pearl Harbor came along, and we missed crucial signals that Pearl Harbor was the intended destination of the Japanese attack. Now, if Yardley were to be prosecuted today, it would be not a hard case, because the intent provisions of Section 798, which govern communications intelligence, are very clear. Basically, the act, it's one of those unusual provisions in American law where the act itself is the crime without an intent provision, as far as I remember. And so, I mean, there might be a constitutional challenge, but the statute itself does not have an intent requirement. As for relaxing the intent standard for the Espionage Act, overall very cautious about changing this act in any way. I mean, I think Congress should move very slowly. Widening it has real costs. Tightening it has other costs. So I don't have an answer, but I think hearings like this with attorneys, and I'm not an attorney, who've worked closely with the act, very much in order.
Thank you, Mr. Chairman. My time is up, but I really want you to know I appreciate the response, and I hope it kind of puts things in perspective here. Sometimes there's no way to possibly anticipate what certain leaks can cause, and in this case, it really caused Japan to completely rewrite or reassess their codes, and potentially could have prevented Pearl Harbor. And in the 9/11 world that we live in, it's a relevant consideration. And I thank you, Mr. Chairman.
Could I thank you very much, Trent, but Professor Stone wanted to get one comment in about your question.
Thank you, Mr. Chairman. I think it's very important not to get fixated on this question of does the speech cause some harm. One of the things that the Supreme Court figured out pretty quickly is that almost all speech causes harm. It's not harmless. And so it made a terrible mistake during World War I, which is that it took the position that because criticism of the war would undermine the morale of the American people, it might lead people to refuse to accept induction into the military, that speech could be punished because it might have a harm. And what they figured out pretty quickly after that is that was a disaster. That you can't prohibit speech that criticizes an ongoing war because it might have harm. Speech does have harm. And the Pentagon Papers case, although the court said there was not likely an imminent grave harm, even Justice Stewart conceded the speech was harmful. Certainly we were revealing all sorts of confidential information about the past, that we had double-dealed with respect to some of our allies, that we'd made alliances that hadn't been publicly disclosed before, that made it more difficult for us to negotiate in the future. If the standard focuses on harm generally, then you've given up the First Amendment.
That's right. Well, thank you very much, and we thank Trent Franks for raising this line of discussion. I turn now to my good friend, the chairman of the court subcommittee, Hank Johnson of Georgia.
Thank you, Mr. Chairman, for holding this very important hearing. Thank you, panelists, for bearing through it.